United States and this honorable court. Case number 20-7062, United States of America, ex-rel Elizabeth W. Kennedy et al. And Elizabeth W. Kennedy, appellant, versus Novo A et al. Mr. Mendoza for the appellant Elizabeth W. Kennedy, Ms. Shawn for the appellee United States of America.
You can begin, Mr. Mendoza. Good morning.
Good morning. Thank you, Your Honors, and may it please the court. My name is Nicolas Mendoza, representing appellant Elizabeth Kennedy. The government has abandoned the district court's reasoning below. The district court's sole and categorical holding was that the alternate remedy provision does not apply when the government elects to intervene in the qui tam. The government does not defend this holding and even concedes that the intervention decision is not necessarily dispositive to the applicability of the alternate remedy provision. Congress wrote the alternate remedy provision with the broadest possible language, specifying that it applied notwithstanding the government's intervention decision under subsection B, and that it applies to any alternate remedy available and elected by the government. Congress did so in part so that the government would not be able to whittle away the relator's share by reallocating funds away from the FCA action. But that is what
I'm sorry.
No.
You want to sum up? Go ahead. Finish that sentence.
Just that is what the district courts has allowed in this case.
Right, sure. So the alternate remedy decision says, we all know alternate to what, right? And it says the government may elect to pursue its claim, singular claim, through any alternate remedy. And claim is defined in 3729 as 3729B2 as essentially a false claim, right? It's not everything claim the government could litigate against a defendant. It is only those claims that involve obtaining money, property through false or fraudulent pretenses. Is that right?
Well, there are 7 enumerated offenses in the False Claims Act,
is misbranding? I'm sorry. Go ahead. Finish your sentence.
No, well, Congress's purpose in incentivizing the prosecution of those claims included preserving the incentive for the whistleblower by allowing the government flexibility, but also guaranteeing the relator a share should the government choose a different proceeding.
A different proceeding for its claim.
For its claim first alerted to it by the relator's qui tam complaint.
Its claim is defined specifically by the statute as a False Claims Act claim.
Well, Your Honor, section 3730 repeatedly refers to the action. So if Congress intended to limit the government's claim to a sort of the formal limits of the FCA action, it would have used the government may pursue the action in another proceeding.
Let me try this asking in the provision at issue here, 3730. Is it E5? Sorry, I'm losing track.
C5.
C5. I apologize. Do you agree that the use when it says the government may elect to pursue its claim through any alternate remedy, that claim there refers to claim defined in the preceding section 3729?
The claim refers to the government's it refers to the government's claim within the valid qui tam action brought under 3729. But
I'm just asking
again,
the definition. Let me try asking a little bit more precisely. I wasn't clear enough. There's a definition of claim in 3729.
Yes.
B2. When they talk about in C5, 3730 C5, the alternate remedy provision, the government may elect to pursue its claim through an alternate remedy. Is your position that claim means what it was defined to mean in the preceding section, or do you think claim there has a different meaning?
I think the claim means given that the sentence says any alternate remedy, we think it
doesn't say for any claim. I'm just asking you, do you think claim means what it's defined to mean in 3729? Or do you think claim means something different?
I think it means something different in that it refers to the government's the claims that the government could bring given the action within the context of subsection C. I think that's what makes the most sense. Otherwise, there would be more specificity from Congress that the claim has to be a formally what was raised under 3729. I'm sorry, I'm going into my rebuttal.
Don't worry about that. We'll give you some extra time for rebuttal.
Thank you, Your Honor.
If I could ask you about another phrase in C5, how do you understand the phrase, if an alternate remedy is pursued in another proceeding, the person initiating the action shall have the same rights in such proceeding as such person would have had if the action had continued under this section, right? To me, that phrase suggests that the action has not continued under this section. But of course, in this case, the action did continue and resulted in a very substantial remedy. So how do you understand that phrase, would have had if the action had continued under this section?
Well, I have two quick points on that, Judge Rao, if you'll allow me. First, the most logical reading of that sentence is that the relator is given the same rights in the alternate remedy proceeding as if the FCA action had been litigated. And that's given the forcefulness of the notwithstanding instruction at the beginning of the provision, as well as the Supreme Court's direction in State Farm to not read out relators' rights without explicit language. But the second point on that is that in this case,
I'm sorry, you mean so a settlement is not encompassed within that phrase? Is that?
Well, in this case, neither action continued. So I think that's a good example of what I mean here. The FCA, the remedy was settled as soon as it was elected, so it did not continue. So in this case, even with the government's more restrictive reading, it literally is correct that the sentence operates to give relators rights as if the FCA action had been litigated, which in this case it did not. And
it
also
doesn't say litigated, it says continued.
Correct, Your Honor. And in this case, it did not continue. It settled as soon as it began. But I would also ask you to consider what would have happened if the government had litigated the FCA action in this case. It doesn't seem conceivable that they would have been able to sustain a parallel FDCA action, if nothing else, because Novo Nordisk would not have consented to it. And it certainly seems even less likely that they would have been able to file the FDCA action after the FCA action had been litigated to judgment. So in terms of fulfilling Congress's purpose of preserving the relator's incentive, our reading here is the most logical. That we shouldn't treat the FCA action as if it had been continued just because the defendant consented to this unusual arrangement of two remedies for the same conduct.
I'm sorry, Judge Rao, are you done?
Yeah, go ahead.
If the government hadn't intervened, could Ms. Kennedy have added a claim for misbranded marketing of the drug under the FDCA?
No, Your Honor.
She couldn't, because that wouldn't be a qualifying claim under the False Claims Act.
That's correct. Her key the False Claims Act does not allow her to plead that. However, she couldn't have pleaded an administrative proceeding for a civil money penalty either, which is expressly encompassed within the provision.
Right.
Really,
on what claims she could bring.
Right.
Mm-hmm. Okay. You're right. The administrative ones are prosecuted by the government, for sure. Under your theory that relators like Ms. Kennedy, who was obviously extremely helpful to the government here, can recover as long as the claim for recovery that's pursued through an alternate remedy arises from the same facts that were disclosed by the QTAM relator. What if the government had undertaken a criminal prosecution of the company in this case, or an individual in the company, relying on all those same facts and obtained a criminal fine? Are relators allowed a share of criminal fines?
Well, Your Honor, criminal proceedings raise interesting questions, perhaps for other statutory reasons, but
I'm just asking whether, under your theory,
right,
it would meet arising out of this same factual situation. What in the text here says that it wouldn't fit within the alternate remedy here?
Well, it would fit within this provision that we're talking about. I'm saying that there may be other reasons why it might not be possible for a relator to seek a share.
Is your position that relators could or could not?
Our position is that within the FCA proceeding before Judge Walton, if there had been a criminal proceeding, the alternate remedy provision would have allowed criminal remedy, but that's very far away from.
I understand it didn't happen here. I'm just asking, had there been, presumably not as part of the False Claims Act, but as a parallel action, a criminal prosecution, is it your position that it produced a fine, a substantial fine? Would Ms. Kennedy have been entitled to a QTAM relator's share of that fine arising out of the exact same facts?
Ms. Kennedy could have moved within the FCA proceeding before Judge Walton, certainly for a share of any alternate remedy, including certainly a criminal proceeding. That was certainly within Congress could have predicted that in 1986. It was very common to go after fraud in criminal actions. So certainly this is very broad language that Congress wrote. But
when I first asked this question, you mentioned that you thought there were other parts of the False Claims Act that would carve out criminal actions, but it sounds like for purposes of this alternate remedy recovery, your position is that criminal recoveries would also be encompassed.
Well, not necessarily the False Claims Act. I mean, the district courts that have looked at this have differed a little bit, but generally the disputes have been over whether a relator has a right to intervene in a criminal action. Sure. But putting all that aside, that's not an issue in this case. For the purposes of the alternate remedy provision, certainly a criminal recovery would be within that language, because otherwise the government could proceed criminally against a QTAM defendant and render them judgment proof. And by the time the relator got to litigate her FCA action, the incentive to carry out that action and alert the government in the first place would have been destroyed by the criminal proceeding. So certainly I think Congress wanted that incentive preserved.
Do my colleagues have any more questions? All right, thank you very much, and we'll give you some time for rebuttal, Mr. Mendoza.
Thank you, Your Honors.
Sean?
Good morning. May it please the court, Karen Schoen on behalf of the United States. And let me just apologize. There is some construction work that just started, so I apologize if you hear it. The purpose of the alternate remedy provision is to protect relators when the government pursues another fraud remedy in place of the relator's False Claims Act suit. But here, the government settlement under the Food, Drug, and Cosmetic Act didn't take the place of relator suit. And indeed, it couldn't have, because it wasn't even a fraud remedy. The government intervened in relator's False Claims Act suit and settled it with relator's consent, and relator received a $7.8 million share of the proceeds. And the district court correctly recognized that in these circumstances, the alternate remedy provision simply doesn't apply.
When you say a fraud claim, is that a shorthand for the definition of claim in 3729?
Yes, Your Honor. I meant a shorthand for, a claim alleging false claims to the government under Section 3729. So the sort of claim that a relator could bring or that the government could bring on its own behalf under the False Claims Act.
If the government here, instead of pursuing that administrative remedy, had added an FDCA claim for equitable disgorgement or just any form of penalty to the existing QTAM action. So it intervenes and it adds claims as it's allowed to do, other claims as it's allowed to do. And let's say through settlement or litigation, there's a recovery that's collectively for all the claims pressed by the government and the false claim pressed by the relator. Would the relator be able to recover a share? If there's just one judgment, what would happen? Would they recover a share of the total judgment, even though it included both False Claims Act claims and an FDCA claim?
No, Your Honor, the relator would only be entitled to a share of the proceeds with respect to relators, the claims that relator brought under the False Claims Act. I mean, a relator can only recover to the extent that she has a valid claim under the False Claims Act, and to the extent the government also asserted other non-False Claims Act claims. The wrong way to phrase that. The relator isn't entitled to a share of those.
What's your best case for that, and for how it gets sorted out if there's just a lump sum damage award or settlement at the end?
I think the courts have held, and I think it's well established that a relator has to have a valid claim to be entitled to recovery, whether it's through
there's no question here. She had a valid claim. There's no question
right
about that.
But I think the corollary to that is, to the extent there is recovery for a claim that could not be brought under the False Claims Act, right? If a relator had brought the FDCA claim or some other claim, I mean, she couldn't, right? That would have been dismissed. She couldn't bring that. And so the fact that the government—
I'm asking when the government brings them all in, then are there—
But I think it's the—
said we through hook or by crook, we're going to have to divvy up the final. I just couldn't find any cases that address this situation.
Yeah, I'm not aware of any cases. I'm sorry, I didn't mean to cut you off. I'm not aware of any cases addressing that specific fact pattern, but I think the reasoning is the same, whether the government brought it in a separate action or brought it in the same action. The relator is only entitled to recover for her claims. And so, the fact that the government brought it all in one proceeding, I don't think changes the analysis or the end result. I think it's the same. Relator is entitled to recovery to the extent that there were proceeds from the claim that she brought. She's not entitled to recover for other claims.
Doesn't the government invariably, in these kinds of cases, bring the False Claims Act piece and the FDCA piece together in one case?
I don't know how it works in practice. I think there are often parallel proceedings, and putting aside the FDCA, there may be other proceedings, whether they're criminal proceedings, there may be proceedings under the tax code, there may be a lot of other proceedings that may go in parallel. I'm not sure that the government always brings, as a practical matter, always brings them in the same action.
I thought as a practical matter, they were brought together and there would be obvious claim preclusion problems if they weren't brought together. They're arising out of the same facts, right?
I apologize, Your Honor. I just don't know how it works.
I mean, the reason
the normal course.
The reason I ask, assume that's the case. The reason I ask is your position makes a lot of intuitive sense, but what do we do with 37D1, which defines the relator's share as 15 to 25% of the proceeds of the action or settlement of the claim? But action to me reads more broadly than fraud claim. Action reads like it is the case in which the FCA cause of action and the FDCA cause of action are litigated.
I think it goes back to the same point, which is that a relator isn't entitled to a share of claims that she didn't even bring. I mean, that the point is to encourage and provide an incentive for relators to bring these sorts of claims, but they're not entitled to recovery for claims that they didn't bring themselves. And I think, I think Congress obviously knew that there may be other proceedings and the government may have other actions to pursue, but those aren't all fraud claims. And here the FDCA action is not, I'll use the shorthand again, it's not a fraud remedy. It has nothing to do with allegations that there were false claims submitted to the government. It's a wholly different that's a wholly different sort of action and sort of violation of the statute. It has nothing to do with fraud against the public fisc.
Ms. Jones, one question I have is, I mean, for the government to prevail here, we don't need to reach. We can decide, I guess, either that the FTC action is not an alternative remedy, or we could decide that the government's pursuit of the FCA claim renders the alternate remedy provision inapplicable, right? We could decide on either one of those grounds for the government to prevail. Which, in your view, is a narrower reading? I mean, there are not very many cases interpreting the FCA, and I'm concerned about unintended consequences of a broad ruling of this admittedly somewhat obscure provision.
I'm not quite sure. I think probably the narrower ruling would just be that I'm not sure that there is really a key distinction between the two, in the sense that an alternate remedy is one that takes the place of a relator's claim. So it's one, as courts have recognized, that the government pursues in lieu of pursuing the False Claims Act suit. And so to the extent that the government actually pursued the False Claims Act suit and settled it, the alternate remedy provision doesn't apply. And so I think that's probably one of your readings. The other would be to say that the FTCA action is not an alternate remedy, but the reason it's not an alternate remedy is because it doesn't take the place of the False Claims Act suit. It's not a fraud remedy. It's not dealing with allegations of fraud against the government or the submission of false claims to the government. It's a very different violation of the law. And so it doesn't, sort of as a matter of law, take the place of a False Claims Act suit. So I think that the two kind of go hand in hand, and I'm not quite sure how to fully answer your question in terms of which is the narrower, because I think they are, in a sense, sort of two sides of the same coin.
Let me ask you some questions then about what it would mean for the government to pursue the FCA claim. So if the government intervenes, but then they proceed with the action, but they proceed to dismiss the action, in that situation, would the FDCA claim be an alternate remedy? Because they've in some sense continued with it. They've entered, they've prosecuted, but they've exercised their prosecutorial discretion to dismiss the case, right? Is that what happens to the FDCA claim in that?
Yeah, I think in this case, if the government had dismissed the False Claims Act suit, that still would not make the FDCA action an alternate remedy. And the reason is because it's not a remedy for a claim under the False Claims Act. It's not a remedy for allegations of submission of false claims to the government. It's a wholly different violation of the statute. So it's not a remedy for a claim within the meaning of the False Claims Act. And so it wouldn't be. Now, I mean, I think stepping back from this case, there might be circumstances where the government's dismissal could result in an alternate remedy if what the government pursued, an administrative fraud proceeding or some other civil fraud proceeding that actually did address the claim, that would be a different story. But I think here the key point is that the action under the Food, Drug, and Cosmetic Act is not, and I'll use the shorthand again, is not a fraud remedy. It's not a remedy for the claim under the False Claims Act.
Here you did settlements. And so imagine the settlement in the False Claims Act suit was for $1,000. And then the simultaneous FDCA action was for $8 million or $10 million or $30 million. And so the government uses this non-FCA claim. The defendant doesn't care. They're going to pay the same amount one way or the other. If you want to stick it under in box A or box B, they don't care. But the government cares because it gets 100% versus 75 or 80% recovery. And so what's to stop the government, under your theory, from doing very small settlements or much smaller settlements of the FCA claim, and then using some non-FCA type claim settlement to put all the real recovery there and to keep the cut the key tam relator out?
I think what stops the government in part is another provision under section 3730C2 capital B, which gives the relator the right to object to a settlement. And a settlement can proceed over the relator's objection only to the extent that the court determines after a hearing that it is fair, adequate, and reasonable. And so I think to the extent there's a concern that the
government
settlement
can go into that and say, look, these are really high standards of proof. We don't think we are going to be able to prevail on a standard of fraud here. And let's make it, not quite so transparent what's going on. And let's say that one's for $1 million. But the government says, it's good. We're really worried about meeting the standard of proof of fraud, which is really hard here. Sort of mens rea, the knowingly here, knowingly as to the falsity. So that's why we're settling that. And then we're going to go over here at the same time, or a week later, the settling defendant's not going to raise res judicata and says, here's our FDCA settlement, and that's where the huge amount of money is. And the key tam relator doesn't know the FDCA settlement's coming. I know it was mentioned here in the settlement agreement, but assume it's not mentioned. Doesn't know it's coming. So there's nothing to object to, or any objection is rejected by the district court. You understand the government's incentives here to split up its claims to the extent it's allowed to through the settlement process.
Again, though, I think it really is a fairness issue. It doesn't turn something that's not otherwise an alternate remedy into an alternate remedy. And I think, there isn't perfect information at settlements, right? And there are a lot of variables and a lot of things to weigh. And, I think to the extent the government has a valid concern about the ability to actually prevail through litigation and obtain a judgment and so that's what makes settlement worthwhile. I mean, I think that's the same sort of analysis and calculus that the relator has to go through, and that the court would have to assess and see whether the government was sort of raising a valid concern, and whether the settlement, taking into account all those sorts of variables and all the uncertainty, is fair, adequate, and reasonable. But I think that really is something.
Does the government have an obligation to tell the relator and the district court judge about any other remedies it intends to pursue for these same facts before a settlement's approved?
I want to be careful here, because I think there may be some times when what the government can disclose, the government may not always be able to share everything, depending on what the other proceeding is. And, for example, in the context of a criminal proceeding, there may be some
let's say for any
confidentiality.
Other
but so I want to be careful.
Civil proceeding, because that's what I think is assumed here. Any other civil proceeding?
Yeah,
by the government.
Again, I do want to be careful, because there may be some confidentiality.
Well, you could file it under seal with the district court, where there's dealing with confidentiality.
Yeah, I mean, I think certainly if the relator raised an objection and questioned the fairness,
no, the relator doesn't know anything. Doesn't raise an objection other than, golly gee, I think we could prove the case, but doesn't object. That doesn't know about another proceeding. Do you think the government has an obligation so that the district court can assess the fairness of a settlement or dismissal decision to tell at least the district court, if not the relator, if there's some confidentiality reason, about other civil remedies being pursued arising from these same facts?
I think the court isn't going to assess the reasonableness of the settlement unless the relator objects. So I think just sort of as a sort of an affirmative obligation, I don't think there's any obligation to.
I said there was an objection, but the objection isn't based on the settlement. The objection is based on, I think, don't dismiss it. I think we can prove our case.
I mean, I guess I'm sorry, I misunderstood your hypothetical. I apologize. I mean, I think to the extent that the court is then conducting some sort of hearing and looking at the question whether it is fair, adequate, and reasonable, then I think it is for the court to, you know, sort of ask what information it wants from the government, and to the extent that the court wants to know whether there are other actions, then yes, the government probably has a duty to disclose that. But I don't want to
Only if the
suggest that
court
there's
asks, to be clear, that your position is only if the court asks.
I may be sort of in over my head a little bit in terms of I can't promise what the government has to do without knowing all the circumstances of a particular case. I mean, I think to the extent we are in a situation where the relator has objected and the district court is looking for information about the case, then I think it certainly would be reasonable for the government to share the relevant facts and circumstances with the court.
Ms. Schoen, on your view, though, the FDCA action is not an alternate remedy at all, and can never be an alternate remedy. Isn't that the government's position?
That's correct, Your Honor. Yes.
Okay. So then on Judge Millett's question, I mean, I think under your view, you wouldn't have to disclose that to the district court because it wouldn't be relevant to the FCA remedy at all.
That's right. I mean, the only question for the court to be considering is whether the settlement under the False Claims Act is fair, adequate, and reasonable, and whether the recovery, the settlement proceeds are reasonable with respect to the claims under the False Claims Act.
So can you just also tell me a little bit why, how do we know what an alternate remedy is, right? So you say very definitively FDCA is not, even though arguably some of those FDCA claims at least sound in something that sounds like fraud to the government. They're not FCA claims. I mean, what exactly is an alternate remedy, or what would be included in that category on the government's view?
I think it's one that is meant to take the place of a False Claims Act proceeding. So it's one that addresses allegations of, you know, false claims submitted to the government. So it's sort of fraud against the public fisc. And so, you know, I think that the quintessential example in the statute in C5 itself is an administrative fraud proceeding, where it's the same, you know, it's basically the same sort of claim. It's just adjudicated in a different proceeding. And I think that's sort of the gist of what an alternate remedy is. It's a remedy for the same claim, but just in a different form than a False Claims Act suit, or it could potentially be another False Claims Act suit. But I think the point is that it's still meant to address the same sort of allegations and the same sort of claim that you bring under the False Claims Act.
Well, what if it wasn't obtaining their FDCA approval to market this drug? You made commitments to make disclosures and warnings to doctors, and maybe warning labels or information with the drug. You made commitments, and the assertion is those were false commitments. You were never planning to keep them because you don't believe these disclosures really should have to take place. And so that's what the administrative proceeding was. You wrongfully obtained authorization to market this drug, or marketed it improperly because you didn't include the appropriate disclosures, and you never intended to.
I think again, it's not that doesn't have anything to do though with fraud against the government in the sense of fraud against the public fisc.
No, but it doesn't have to be the fisc. You're obtaining property as well. You're obtaining a license. You're obtaining a permission and authorization from the government through false pretenses. You say that isn't included? It doesn't mean anything in the definition?
I don't know if there would be some theory of liability under the False Claims Act, but that's not the suit we have here.
A request from the government is included. To obtain something, money or property.
Your Honor, I don't want to speculate in terms of whether there would be some theory of liability under the False Claims Act. I think the key point here, though, is that's not the situation we have here.
No, but you're asking for. We just don't get to write opinions that way. And so what assurance do we have against the government especially in this double settlement situation where Judge Katz's wise point about res judicata isn't going to be implemented. What protection does a qui tam relator have if we adopt your definition, adopt the rule you want, in a case where the government puts most of the weight on the so-called non-FCA claim and most of the recovery there, but not so much that it's obvious what's going on, and maybe doesn't say a word when the FCA settlement is going through? What protection?
I think that the key protection is C2 capital D.
That can't happen if nobody knows what's going on, and you weren't willing to say that there was any obligation of the government to be upfront with what it's doing, even apart from a confidentiality concern. So I don't see how that's any protection at all if nobody else knows.
But I think the fairness of whether the settlement under the False Claims Act is fair, adequate, and reasonable, I think is sort of an independent question. The fact that the government may have an action for other claims that are not false claims, not the sort of claim that you would bring under the False Claims Act, the fact that the government may have that other action is really, in some sense, beside the point. I understand your concern about the shifting proceeds, but I think if that's the concern, then it's really just that what you're saying is that the settlement under the False Claims Act was not fair, adequate, and reasonable. That taking into account all the various, things to consider and the risks of litigation, that still is not fair, adequate, and reasonable. And that's what C2B is meant to address. And I think that's what relator can raise her hand and say, I don't think this is fair, adequate, and reasonable. I think the government could really prove has a stronger claim and could really prove more and get a better deal at litigation than we're getting here. And I think relator can do that whether the government is pursuing or may pursue a separate action for a wholly different violation of the law.
My colleagues have further questions? All right, thank you, Ms.
Thank you, Your Honor.
Okay, Mr. Mendoza, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I just want to quickly discuss the relatedness of the FDCA action. This is the exact same facts first alerted by my client in 2010. It alleges a form of fraud and practice, which is introducing misbranded drugs. There's no additional actual difference between the actions of the defendant in both proceedings. And the government settled both of them simultaneously with Novo Nordisk's consent, but then waited until after the FCA action had been resolved to file the FDCA action in the same court before the same judge with the same Department of Justice attorneys. So I disagree with my friend from the government that this is not in any way a form of fraud. This is the Congress did not impose any sort of formal fraud requirement on the alternate remedy. That's why it said any alternate remedy, notwithstanding the government's decision to intervene. And Judge Katz, you're completely correct that this is a very unusual thing for the government to have done, the separate actions. And as Judge Millett, you were discussing it wasn't a relator was not there's no right for the relator to know to participate in settlement negotiations or to get information from the government. What's afforded the relator is a relator share right and the right to object. On the right to object, I'd also like to point out that the district court has made no findings as to whether relator agreed to waive her alternate remedy rights, and there was nothing other than a reference to an FDCA action in the FCA settlement to the drug Victoza. It could have been for any conduct. It's certainly not a very strange thing for the government to do.
Well, did your client inquire? I mean, your client actually was given notice of another settlement. Did your client seeing that in the settlement agreement go, hey, wait, I need to know more about what that is, what the claim is there that's being settled before I can tell whether this is fair?
Your Honor, the counsel for relator was told that, I mean, again, the district court didn't address this, but Counsel for Relator was told that this was all the government could get from defendant Novo Nordisk.
I know,
When
but you were told there was another action or settlement out there. My question to you is simply, did you inquire further about the relatedness or not of that proceeding to the factual allegations at issue here?
I believe counsel for Relator did inquire, and there was a back and forth. This is discussed in the Fraser Declaration.
Did they alert the district court to any concerns, or they had no concerns based on this back and forth?
As far as I know, there was no communication about this with the district court. And in fact, the district court wasn't aware of the FTC action at all until it was filed in the district court on September 5th, 4 days after the FCA action was dismissed.
So Ms. Kennedy's counsels didn't raise any concerns about this, or even just questions or need for information about this with the district court?
Well, Your Honor, I can't speak. I wasn't there, but my understanding is this is discussed in the Fraser Declaration. I believe there was a back and forth over
whether it was raised with anything was raised with the district court, and you said the district court didn't.
No, Your Honor. Relator was not in a position to raise it with the district court. Okay. And the government has many remedies and many possible actions against pharmaceutical companies, and this could have been for any for unrelated conduct, and given the unusual structure of the settlements, that's what would have made sense. So, thank you.
Colleagues, have any questions? No. Thank you to both counsel for your helpful arguments. The case is submitted.
Thank you.
Case number 20-1015, Cross Refined Coal LLC et al. Versus Commissioner of Internal Revenue appellant. Ms. Bringer for the appellant, Mr. Bishop for the appellees.
You may proceed, Ms. Bringer.
Thank you, Your Honor.
Bringer?
Bringer, yes, that's correct, Your Honor. Thank you. Good morning, and may it please the court. My name is Nora Bringer, and I represent the Commissioner of Internal Revenue in this appeal. The issues the Commissioner raises on appeal concern the organization of cross-refined coal as a partnership. It is especially tempting to abuse the partnership form to transfer tax benefits among taxpayers, so partnerships come under special scrutiny for federal tax purposes. This appeal is not about whether Cross engaged in actual business activities that qualified for refined coal credits. The IRS agrees that it did, and that AJGC, which had all of the non-tax upside from Cross and the lion's share of the downside, may claim the tax benefits from Cross. A key element in a partnership, the Supreme Court tells us in the Tower case, is that there is a community of interest in the profits and losses. Here, there was not.
Your argument was that Gallagher had the lion's share of risk. And I'm not sure what the lion's share has a technical definition or not. As long as the other partners had a material risk of losing their investment or a significant portion of it, would that suffice, or could it still be considered an improper partnership for tax purposes?
Well, Your Honor, the Culbertson test is a holistic test, looks at all of the facts, and an important piece of that.
I'm focusing on your lion's share argument.
Yes, Your Honor. So an important piece of that is the downside risk. It's not the whole story, but it is an important piece of that. And here, the tax court grossly overstated the amounts that Fidelity and Schneider had at risk in Cross.
But if they had, just under my question, let's just, apart from this case, the lion's share may well be in one partner. But if the other partners have a material risk of losing substantial amounts of their investment.
Your Honor, a material risk is, I'm sorry.
Would that be, I know no one factor is dispositive, but for your concern here where you're not challenging You're only challenging two of the factors. What role does it play if they have material risk, but someone else has most of the risk?
Your Honor, partners certainly can have differing levels of risk in a partnership. That's permissible. Here, the concern is that on the risk side, the balance was so out of balance, especially compared to the anticipated tax benefits that Fidelity and Schneider anticipated out of this partnership, that the risk at the end of the day is more like de minimis. But a material risk would weigh in favor of a partnership. That's true even if there was an imbalance in risk among the partners. The other side of the coin, though, on the economic upside, we acknowledge that Fidelity and Schneider had some level of risk. The commissioners never argued that there was no risk in their investment in Cross. The argument is rather that there's this huge imbalance between the downside risk and the anticipated tax benefits. But on the upside of the story, looking at the business operations of Cross, AJGC is the only entity here with an upside potential from the underlying business of refining coal. In the Culbertson case, the Supreme Court tells us that whether a partner enjoys the fruits of the partnership is strongly indicative of the reality of his participation in the enterprise. The Historic Boardwalk and the TIFD case in Chemtech, those circuits.
Can I ask you something back on, again, these risks?
Yes.
And I'm sure I'm not going to pronounce it right, but they went into, I think, three or four of these partnerships simultaneously. Three, is it right? Three, yes. And one of them, is it Jeffries,
I believe.
Pronounced Jeffries. Do you dispute that they lost money and lost their investment? They made no profit at all under that one?
Well, the facts of this case are really focused on the Cross partnership. That is the only partnership at issue here.
But you dispute what happened in that partnership, which was doing the same thing as this one?
No, Your Honor, but a critical piece is that
go ahead.
The protections with respect to the initial investments, in particular for Fidelity, were quite different in those partnerships. With respect to Cross, Fidelity had liquidated damages provisions that really limited.
It didn't have that in the Jeffries?
I don't believe so, Your Honor. I'm not certain about that, but I don't believe so.
I'm sure counsel for the other side can answer that question. But if they did, what happens then?
Your Honor, there certainly was some downside risk in these partnerships. The commissioner doesn't dispute that. The issue is rather that on the one hand, the tax court grossly overstated the amount at risk. And given how important that was to the tax court case here and to looking at the overall partnership, the errors of the tax court on the downside really.
But I'm trying to get to this grossly overstated when we know they lost, it looks like, everything on the Jeffries partnership. And at the time, I take it we look at the time they entered into the partnership. Is that the?
Well, Your Honor, certainly the question is what was their intent in entering the partnership? And when they entered the Cross partnership, Schneider thought, based on projections from AJGC, that a $7 million investment would result in $140 million of tax benefits.
If everything went perfectly for 10 years.
Yes, that's correct, Your Honor. And Fidelity had.
And what evidence was there that everything would go perfectly for 10 years at the time they entered into the partnership?
Well, Your Honor, the evidence in the record about what the investors anticipated would happen is their internal documents projecting the anticipated upside from these partnerships. There is not evidence in the record.
Did those projections describe that as sort of a best case or hoped for scenario, or did they say this is a lock?
So the projections from AJGC, the tax court, did describe them as a best case scenario. Fidelity's projections included a range of minimum production and maximum production from about $100 million to about $150 million. But either way, as the tax court found, they anticipated very high returns from this. Now,
Ms. Springer, why is that a problem in a case like this where, as you say, the IRS is not contesting that there are actual transactions going on, right? I mean, a number of our cases talking about the relationship of the economic substance or where there's sort of sham transactions. But here, no one disputes that there was actually coal that was refined and then sold and used to produce energy, right? So you have the actual activity that Congress sought to incentivize. And so why exactly should we be focusing on, the various economic decisions that the partners made about the type of risk to undertake?
Well, Your Honor, there is no dispute here that Cross did refine coal and did sell that coal to Santee Cooper. That's absolutely right. But economic substance is not sufficient to sustain the validity of a partnership. This court was very clear about that in the ASA Investorings case. Even if there was economic substance there, that wasn't enough to save the partnership. In the Southgate Master Fund case, the Fifth Circuit put it this way, that the sham partnership analysis focuses solely on the question of whether there was a non-tax business purpose that necessitated the partnership's existence. So the question here is not, did Cross actually refine coal? The question is, were Fidelity, Schneider, and AJGC truly partners in that underlying business of refining coal? We've discussed the downside.
The tax court found that the Gallagher sought out partners, found as a matter of fact, that Gallagher sought out partners for the purpose of spreading its investment risk. This is on JA 1794. Spreading its investment risk over a larger number of projects, not exceeding its parent's company limited appetite for coal, allowing Gallagher to learn from lessons spreading across facilities. You can learn from what's going wrong in one project the other, and to expand its royalty earnings on the ChemMed technology. You haven't challenged those factual findings.
No, Your Honor, that's correct. We haven't.
So as to Gallagher was looking for partners for legitimate non-tax reasons, correct?
So the tax court found that Gallagher was looking for entities to share its risk, but Fidelity and Schneider did not.
Let me ask this one more time. So Gallagher was looking for partners for legitimate business reasons, non-tax reasons.
That is what the tax court found, and we don't challenge that in appeal.
Yeah, so we're taking that as a given. And then the the tax court also found that these other Fidelity and Schneider came in and did due diligence and kept themselves updated on all types of information and were being involved in what was going on with the refining of this cleaned up coal. They weren't just sort of passively mailing it in. You don't dispute those facts, do you?
No, we don't, Your Honor.
But you dispute the fact that they got wiped out on one of the three partnerships. You don't dispute that fact.
That's correct, Your Honor. But focusing here on what happened with Cross.
Schneider didn't have the protection, the liquidated damages protection that Fidelity did. You don't dispute that either.
That's correct, Your Honor. They had different provisions in their membership purchase agreements.
If Fidelity and Schneider had stuck with this partnership for its 10-year term, they'd stuck with it despite everything that was going on, they would have lost money. Do you dispute that?
Your Honor, there's no support in the record for that conclusion. So
no one was buying any more coal. They were just paying expenses, ongoing operating expenses. No one was buying the coal. They'd stopped.
Well, that's not correct, Your Honor. It's my understanding, and I believe this is in the record, that Cross did eventually begin refining coal again after Fidelity and Schneider exited.
How long after?
Go back to.
How long after?
I'd have to get you the specific date, Your Honor. I believe it was in 2014, but I'm not certain.
And I'm lost track what year of that 10-year period. What was the 10-year period?
So Fidelity and Schneider exited in 2013. They began refining coal in 2010. Mm-hmm. But Fidelity and Schneider didn't join.
Did they continue refining this from 2014 on?
Your Honor, that's not in the record, and I don't know.
So you didn't. The government didn't show that, in fact, had they stuck with it, they would have gotten all these profits, or at least the lower end of their projections.
No, Your Honor, the government didn't show that, but neither did Cross, which bore the burden of proof here to show that the IRS's determination was incorrect. If I may, Your Honor, I recognize that I'm into my time, but if I may make a couple of points on the upside. So Fidelity and Schneider didn't join Cross to
Sorry,
share in Gallagher's risk.
Sorry, before we go to upside, can I ask you another question about downside?
Absolutely.
So as I understand, your theory is that Fidelity and Schneider didn't really have much skin in the game. And the way you reach that conclusion is by saying, ignore all of their contributions that were made in months, 1 month after the tax credit had been realized, because they knew they were going to get some benefit. But I mean, that's the benefit of 2020 hindsight. When they enter into the partnership, they do what partners always do, which is they make a commitment to fund the operating expenses on a pro rata basis, and they're on the hook for that. And if there's a good month, they'll happily do it because it'll produce a profit. If there's a bad month, they're still on the hook for funding the expenses, as they had to do in many months where they were losing money. So why don't we look to the scope of the commitments they made when they formed the partnership, instead of ignoring all of the expenses that were funded in months that turned out to be successful?
Your Honor, if you want to look at what the partners understood they were getting into with respect to the operating expenses, there are excellent examples of this in Fidelity's internal documents, and this is at page 1480 of the appendix. In December 2009, on the cusp of formalizing its investment in Cross, Fidelity wrote that the ongoing operations expenses were a contingent liability that exists only if qualified tax credits are produced. And it also said these expenses would be paid quarterly in arrears as the tax credits are generated. So these operating expenses, Fidelity knew from the beginning would be paid in arrears, and the amount of money committed in the absence of refining coal was minimal compared to the expenses when Cross was refining coal.
They were on the hook to pay expenses, and they did pay expenses in every month where no coal was being produced.
Yes, Your Honor. As the tax court found, the tax court concluded that there were $2.9 million in expenses, which is a very small portion of the overall operating expense contributions here.
Which makes sense. Most of the costs are variable here.
Yes, Your Honor. The vast majority of them are variable.
So the gist of your objection seems to be that this looks like a really good deal in months where things are working out.
No, Your Honor, the gist of the commissioner's objection to this is that this looks like a situation where Fidelity and Schneider put a very small amount of money in upfront, had very small amounts at risk from these operations expense contributions, and then in the context of the anticipated tax benefits that they thought would result here, that is not a substantial factor weighing in favor of this being a partnership.
Okay.
On the upside part of this, if I may just say a couple of things. First, Fidelity and Schneider did not join Cross to share in Gallagher's risk. So the tax court did find that that was an interest of Gallagher, but Fidelity and Schneider, as rational economic actors, needed an economic upside out of this investment. And they were totally indifferent to the economic upside of Cross's operations, except for the tax credits. Now, it's not the IRS's position that there must be a pre-tax profit in this kind of situation. What is required is some kind of economic upside from the underlying business, not just tax benefits. Legitimate partners have meaningful upside potential or a meaningful stake in the operations of the company they've invested in.
Why
And
is that a
here,
legitimate? I'm trying to figure out how that works when you have, as here, a tax benefit that's designed to encourage people to undertake activities that they wouldn't do absent the tax benefit. It wouldn't be profitable, at least pre-tax, and they would have no interest in doing it pre-tax. I just don't understand how you said you don't You don't have to have a pre-tax benefit, but they have to have some interest apart from the tax benefits. Like maybe I just didn't understand what you were saying. They're supposed to have pre-tax.
So the IRS's position is not that a pre-tax profit is required, but the IRS's position is that there must be some kind of economic upside in the underlying activities of the business. So as an example, in this case, Gallagher
Economic upside, there must be an economic upside to the business apart
in the underlying business. So in this case, Gallagher had
underlying business, you mean the production of this refined coal?
Yes, the refining of coal.
There has to be some upside when?
Through the operations of the business. So if I may, Gallagher is a good counterexample. So Gallagher had potential upsides and downsides through its ownership of the technology, through its role as a licensor of the technology, through receiving the technology licensing fees from Cross, and through the mechanism of that technology licensing fee. Gallagher was solely exposed to the ups and downs of the operating expenses when Cross refined coal, which was the vast majority of the operating expenses.
But I think the difficulty is that the way it looked, Gallagher and its lovely technology were going to go nowhere without partners. They weren't going to be able to do anything without partners, because this thing just isn't going to work financially. Even they were not going to be able to do this operationally without other people to come in and share the expenses and share the benefits, right? So it seems a little odd to me to say, let's just look at Gallagher, when Gallagher said, I got to have partners. And Congress said, you know what? We want people to do this, and they won't do it. People won't jump in and get involved in this unless we give them this tax benefit. And I don't understand why it matters that they said, okay, Congress said, we'll make this economically viable for you with a tax benefit. We're willing to do it in light of that tax benefit. Is that your position? That's when someone says we're willing to do it because of the tax benefit, we wouldn't do it without the tax benefit, that it is therefore not a legitimate decision to enter into the tax partnership?
No, Your Honor, the tax benefit, the tax benefit could certainly be part of the calculus, but the question is, did these entities really intend to enter into the business of refining coal together?
Ms. Berg,
And
why can a tax credit not be the entire reason for getting into it? If the tax credit is the only thing that makes this type of business economically feasible, why can't that be the only upside potential for the partners? I mean, that seems to be a decision that Congress quite clearly made, and then reinforced after 2008 when it took away the, enhanced value of coal provision. So I guess, is the government's position, I'm just not sure that the government's position is consistent with the creation of these tax credits by Congress. I understand the IRS wants to protect the public fisc and get as many tax revenues as it can, but that doesn't seem to be the policy that was pursued by Congress.
Your Honor, Congress was certainly intending to encourage refined coal through the tax credit. There's no question about that. What Congress was not encouraging was for the creation of partnerships to transfer those tax benefits where the purported partners had minimal skin in the game and no economic upside from the underlying business. Here, Gallagher had all of the upside from the refining of the coal and the lion's share of the downside risk, as we've discussed. Now, in this court's opinion in ASA Investorings, this court really focused on the fact that the key is a non-tax business motive for forming the partnership. And quoting a 1944 opinion from the Second Circuit and National Investors Corporation, the court wrote that escaping taxation is not business. So the business purpose for Fidelity and Schneider can't just be to reduce their taxes.
Isn't this idea of escaping taxation or evading taxation very different from benefiting from affirmative tax credits, right? Isn't that a different thing? In fact, it's a very different thing to create a structure to just simply evade tax versus to create a structure to to take advantage of tax credits, right? Where when Congress creates tax credit, effectively creates a different kind of economic market for the underlying good, right? Here, refined coal. And so there's a business that's simply taking advantage of that different market incentive that Congress has created.
Well, Your Honor, with respect to how it works out on the bottom line of a tax return, evading tax and taking advantage of a tax benefit like a tax credit do form the same function.
Sure, but
I think it might be.
It's very different public policy, though.
Well, Your Honor, in terms of encouraging the refining of coal through the tax credit, absolutely. There's no question that's what Congress meant to do here.
I mean,
but
Congress
did
wants
not
people
mean
to take advantage of tax credits. It doesn't want people to evade taxes.
Yes, Your Honor, but AJGC in this constellation of members of Cross undertook the activity that Congress meant to encourage here. Fidelity and Schneider did not. AJGC invested in the technology. AJGC had all the partnerships with the utilities. AJGC, took the risk on not only the technology, but the operations of Cross. And so here, AJGC
Could Gallagher have done it by itself? They're finding that Gallagher would have done it by itself.
Well, Your Honor, the tax court did find that Gallagher brought in partners to spread its risk. Whether it would have done it without partners, but that's probably a fair inference there.
Didn't have an interest in doing it by itself. So what Congress wanted to have happen wouldn't have happened if partners didn't come in, or seems unlikely to have happened.
Your Honor, Congress, in fact, anticipated that people might join together to refine coal. What Congress did not anticipate was that entities could come in and put a very small amount of money into a partnership and reap the tax benefits without really being full participants in the business. I'm sorry, Your Honor.
This doesn't feel like a small amount of money, but maybe that's just the salary bracket from which I'm looking at it. It looks like a lot of money.
Well, I understand that our bottom line is
it's not a token payment, and it was ongoing payments, even whether or not tax credits were being generated.
But the vast majority of those payments, though, Your Honor, were not truly at risk. And so when looking at the risk of these entities in Cross, those payments and arrears for operating expenses simply shouldn't have been part of the equation. So in context, which is important, it's not my salary that this is in the context of, it's in the context of, how much do they put in and how much do they anticipate out of the partnership. And that difference here is quite striking. So thank you very much. Yes, any other questions?
Okay, thank you. We'll hear from Mr. Bishop now.
May it please the court. Just let me put straight that Fidelity and the other partners had exactly the same agreement as to Jeffries as they did as to Cross. And if you look at JA 761, that is the membership purchase agreement that applies to all three of the partnerships, Cross, Wynyard, and Jeffries. And at page 779 is the liquidated damages clause that applied equally to Jeffries. And the liquidated damages clause has conditions. You can't exercise it willy-nilly. At Jeffries, the partners did not exercise it within 30 days of the plant being closed down, because they had decided that they were going to move the machinery, the plant that they had bought, to another utility. And so they didn't exercise the liquidated damages clause in time. When they did pull out, Fidelity lost $2.9 million in after-tax money, and Schneider $700,000 in after-tax money. And what Judge Gustafson held here is that at the time when the partners entered into the partnership, they didn't know if tax credits would ever be generated or in what amounts, and they could even have failed to recoup their investment. Just what happened at Jeffries, because there were all these risks, demand risks, regulatory risks, environmental risks that stood between them and obtaining the credits. So, Jeffries, I think, shows without question that what we put into the partnership was at risk. And what we put into the partnership, Ms. Springer talks about, this being a small amount. What we put into the partnership was exactly what it costs to refine coal. We bought a plant that cost $6 million. We put in a $1.5 million escrow in advance to cover operating expenses. And then we paid those operating expenses each month. And those are the expenses of running an ordinary business. And I can refer the court to JA 955, which is a statement of account for the cross partnership for 1 month for October of 2010. And it lists what all those expenses are. It indicates the escrow amount at the top and at the bottom. And it talks about all the expenses that we pay, which are payroll, rental, materials, the chemicals, safety services, the cost of running an ordinary business. And that's what we were doing. In ASA and BC, I'm sorry, Judge Katsas.
Yeah, I was just going to take you to ASA. So your position makes a lot of intuitive sense for the reasons my colleagues have explored. Congress wants this kind of activity to be undertaken, and you all are undertaking it. But ASA has this very broad language, which says that either the transaction, which is the underlying production of coal, or the entity, which is the creation of the partnership here, is a sham in the absence of a non-tax business purpose.
Yes, sir.
How do we make sense of that language in these cases where no one would have undertaken any of this, Cross or anybody else, without the tax credit? So in some sense, none of this happens without a tax purpose.
Yes, Your Honor. Well, it's true that the tax court found that there was no incentive, that it was uneconomic to enter into this business without the credit. But at the same time, there is a non-tax business purpose here, and that is to refine and sell coal that meets the standards that Congress has laid down. And what this court said in ASA and BCP when it was contrasting this non-tax business purpose was it drew a contrast between business in the ordinary meaning. That's a quote in ASA from Learned Hand, and transactions that are so structured in the extreme such that they are just a facade. And then it talks about that sort of business as being, essentially a worthless business. And again, in BCP, again, this contrast between a non-tax business purpose and a real business, it talks about practical economic effects of the business apart from tax effects. Now, if you look at those things, business in the ordinary meaning, was this a facade? Are there non-tax business effects? The answer is yes, it's not a facade. We have a plant, we have employees, we refine coal. 94% of our revenue comes from the sale of refined coal to the utility. Only 6% of our revenue is from the credits. And again, referring the court to that document at A955, there are an awful lot of economic effects in there that have nothing to do with tax, paying our employees, buying the chemicals, We are running a real business. We are putting into that business exactly what it takes to run a refined coal business. And what we are getting out of it is two streams of revenue. One is for the sale of the refined coal, and the other is the tax credit. And the tax credit is exactly in the amount that Congress specified you should earn per ton of refined coal. So even although no one, not just us, no one would enter this business without the incentives that Congress provided to encourage this activity. In order to get there, you have to run a real business which has its own real economic effects. So that's my suggestion, Judge Katsas. And obviously the context in ASA and BCP is nothing like that. In those cases, you're on the structured side of the transaction where there is no point to the business other than to exploit tax rules that are not incentive rules like the refined coal credit, but that are for some other purpose entirely. You know, in ASA, it was the installment rules. In BCP, it was the contingent liability rule. So nothing to do with the particular activity, but you squeeze a fake business in a papered, structured transaction to take advantage of those rules. We are doing exactly what Congress incentivized and spending exactly the amount of money that it takes to run a real refined coal business on those credits.
Thank you.
You had argued about the commissioner's mistake being that it wasn't looking at, you know, a risk-adjusted, I think you call it a risk-adjusted ratio between the investment and the tax benefits. Right. I might not be describing it just right, but you thought there should be a risk adjust. You know, the government sort of had the best.
No, Your Honor, no. It's all relevant. I mean, that's the beauty of the Culbertson test. You take all of this into account here, and the court recognized there may be cases where the disparity could be telling, or where the lack of non-tax profit could be telling. But the beauty of Culbertson is you take everything into account. The tax court here made findings as to the projected amount of the benefit, the actual much smaller amount of the tax benefit that was received, and the amount of money that we invested. And it didn't use the word ratio, which the government seems to think is a legal requirement, but it considered all of those facts. And what it found was that in context, we were putting in the amount of money that the investment that was required to run this business, and that the after-tax benefits that we got were a fraction of our projections because risks that we knew about, as a result of our due diligence came to pass.
I'm trying to figure out when we're sort of looking at investment and discounting by risk, and then in BCP we looked at not the projected tax benefits but the claimed tax benefits, and yet the inquiry is supposed to be, as I understand it, the intent when entering into the partnership. So
yes, sure.
we'd be looking at claimed tax benefits or projected tax benefits.
No, look, the tax court here found that we were aware when we entered into the partnership as a result of our extensive due diligence of the risk. We were even aware of the bromine risk. We were aware of the demand risk. We were aware of the regulatory risk. So those projections, the district court said, were a best case scenario, and they depended on operating at full production over the full 10-year period. We knew that wouldn't happen. We couldn't put a number on that. We did put on an expert at trial who ran Monte Carlo analysis to show what the real, the range of losses and gains could be. The partners didn't do that, but they knew that they had significant risks. And so, the best indicator here of what we could have anticipated at the worst at the time when we entered into this partnership are the $19 million that all three partners received between them as tax benefits, or the situation in Jeffries where demand dissipated and the partners lost $3.5 million. So I agree, Judge Millett. There's no doubt that, you know, an initial protection, particularly in a case where everything is structured, where everything is fake. All right, this is a paper transaction where there's no real risk, where there's no upside that isn't controlled, where returns are guaranteed, fixed returns are guaranteed. Those sorts of situations, then of course, you know, the unvarnished projection may be very, very telling. But here, the partners knew of the risks and knew that that projection was subject to actually refining and selling coal, and all of these problems that arose, the loss of the permit and the shutdown for 3 years because of the bromine, those have to be considered as well in this situation. And that's the beauty of Culbertson, Your Honor, that Culbertson, which the tax court faithfully applied here, allows you to take all of these into account. Ms. Bringer's theory here, which imposes these sort of fixed rules on top of Culbertson, doesn't, and really doesn't allow you to account for the fact that this is conduct.
Well, I'm not sure. I'm not sure that that's what she's proposing, as opposed to trying to put some meat on the bones of, you know, sort of anticipated recoveries and risks factors, you know, prospect of recovery factors under Culbertson. I mean, there has to be some meat on the bones and some way of actually comparatively analyzing those. If that's what their ratio and stuff is seeking, then that wouldn't be illegitimate. It's just whether it was appropriately adjusted for risk or not when they had their best case scenario.
Well, I agree absolutely, Your Honor, that all of those, you know, the amount of projections, the amount of actual returns, the knowledge of the partners as to the risk when they made the projections, those are all relevant factors. But as I read the government, it thinks that ratio is determinative, and that's just not the case under Culbertson, and it doesn't allow courts to take account of the disparate facts in cases, you know, like this, which is an unusual case. We have real partners who, as the tax court found, were engaged day to day in the operation of this business. Any decision to spend more than $5,000 had to be passed on by all three of the partners. They were engaged on a day-to-day basis in operating a business and paying its expenses. And I do want to address just on the operating costs issue, because Ms. Bringer did bring up this claim again that the operating expenses were not really at risk, and that's wrong. And it's wrong for two reasons. It's wrong because there was an escrow that we funded in advance for $1.5 million. And as the document at 955 shows, that we replenished that escrow each month. So we were actually paying in arrears. But more important than that, when we refined the coal, the credits accrued. They weren't earned. And in fact, the government in this case, in its answer, section 7G of its answer, did not concede that the refined coal here was qualified. That is, that it met the emissions reduction requirements of the statute. At trial, it put on an expert witness who said that the lab testing that we did was inadequate, and that in order to qualify, the testing should be done at the stack. Trial counsel tells me that they did not know until the government's closing argument in this case that the government was not going to challenge the qualification of the coal. In another one of these cases, which is under audit at the moment, the government is challenging qualification of the coal. We had absolutely no guarantee at the time when we produced this coal that we would ultimately be allowed the credits over this qualification issue, and the trial, you know, showed that to be the case. So all of those operating contributions were at risk, and should not be discounted, you know, essentially ignored altogether, which is what the government would like to do here.
Okay. My colleagues have any further questions? All right. Thank you very much, Mr. Bishop. Ms. Bringer, we'll give you 2 minutes for rebuttal.
Thank you very much, Your Honor. I appreciate that. As an initial point, Judge Katsas asked about non-tax business purpose. And the non-tax business purpose that is relevant here is for the formation of the partnership. And was there a non-tax business purpose to form the partnership? As discussed earlier, Fidelity and Schneider did not have a non-tax business purpose to join this partnership. Their only reason to join this partnership was for the tax benefits. In addition to that, they knew.
Sorry, why is that? Why do you reach that conclusion with regard to Fidelity, but not with regard to AJC? I mean, you can look at this one of two ways. One way of looking at this is, as Mr. Bishop said, they're doing real stuff. They're running a business, they're producing coal, and that counts as a business purpose, even if the business would not be profitable but for the tax benefits. Or the other way you can look at it is you can understand the phrase non-tax business purpose to mean that the enterprise or the partnership have to make sense without regard to tax benefits. And that seems to prove way too much, including that AJC wasn't legitimately engaged in a business.
Your Honor, AJGC had a number of ways to have a possible upside from this business. Through its investment in the technology, through the possibility of reducing operating expenses, which would have inured entirely to AJGC. So AJGC is a really different position from Fidelity and Schneider when it comes to the business of producing coal. And the question,
are you saying they might have gotten into this business but for the tax credits?
No, Your Honor. The point is that AJGC had an economic upside potential, for example, from reducing operating expenses at Cross. Fidelity and Schneider both had employees who testified that through the technology licensing fee, it provided an incentive for AJGC to reduce costs. So Gallagher is really the entity that's engaged in the activity that Congress meant to incentivize here, which is the production and refining of refined coal. Now, context matters. And it seems that there's a fair amount of agreement in the argument today that the tax court should have considered the downside risk versus the upside, and whether that's the anticipated tax benefits according to the documents that were introduced at trial, whether that's some kind of risk-based assessment, which there's no evidence of in the record here, but even if that's the proper comparison, the fact is that the tax court simply didn't consider that. And not only did it not consider that, it mistakenly thought that Culbertson barred that kind of contextual comparison. And that was a significant error in the tax court's opinion here. At the end of the day, Congress did indeed want entities to refine coal and sought to encourage that through the refined coal credit. But Congress did not intend for the formation of invalid partnerships to share those tax credits by abuse of the partnership form. And in the commissioner's view, that's what occurred here. Are there any further questions?
All right. Thank you very much to both.
Thank you very much
for their helpful arguments, and the case is submitted.
Thank you.
This honorable court is now adjourned until Tuesday, April 13 at 9:30 a.m.